G'day, I'm Stephen Page from Page Proven Family and Fertility Lawyers in Brisbane. Proudly, I'm a dad through surrogacy and egg donation. My husband and I had a very difficult surrogacy journey here in Brisbane. So we're very much the exception, and by that I mean most people undertake surrogacy overseas. But it was such a joy when our daughter came along, and she has given us joy every day of our lives. Really transformed our lives. And for her, of course, life is normal. She's got 2 dads and friends and school. But why I'm talking to you today is to ask you, please, oh please, if you have had anything to do with surrogacy, make a submission to the Australian Law Reform Commission surrogacy review. Now, the starting point is just to go to the ALRC website, www.alrc.gov.au, and from there you'll see there's a reference to the surrogacy review, and from there just click on the link and you'll see about an issues paper and also 27 questions. Submissions finish about a month from today on the 11th of July of this year. So you've got to get them in. If you're going to make a submission, get them in, please, by that stage. By all means, share them with me. You can send them to me via email, Stephen, STEPHEN, at pageprovan, PAGEPROVAN.com.au. Of course, I'll be doing my own submission. I'm in the fortunate position that I'm a member of the advisory committee to the ALRC on this surrogacy review, and in that role I've been told that I can also make a submission, so I will be making a submission. The people that the ALRC wants to hear from particularly are those who've had lived experience with surrogacy. If you've been a surrogate or a surrogate's partner or an intended parent who's gone overseas, or a donor, or above all, someone who's been born through surrogacy, please let them know. If you're someone born through surrogacy and life is normal, please let them know. There's a lot of misinformation about surrogacy. Recently, there was a law case in Brisbane where a judge referred a Queensland couple off for prosecution for undertaking commercial surrogacy overseas. And one of the questions I was asked about that case was, how's the baby going? Is the baby okay? And the answer is, well, the baby is okay. The baby's fine, the baby's thriving. But it's the unknown. Anyone looking in who hasn't done surrogacy doesn't know what the impact is on members of family. And it's really important to speak up. It may not seem important to you, but it will help change opinion. There are people who are absolutely opposed to any surrogacy happening at all. And it's important at this moment to speak up and say, well, this is our journey. Now, there have been 27 questions asked by the ALRC, and I'll just move my head to a different screen and read those out. The first one, question 1, and it's called Insights from People with Personal Experience of Surrogacy. These are the people the ALRC really, really, really want to hear from. If you or someone close to you has had personal experience of surrogacy, please describe what parts of your experience were positive, what parts of your experience were negative, what could be improved, and how. And in your response, please let us know how you were involved in the process. For example, if you were a surrogate, intended parent, or child born through surrogacy, if the process took place in Australia or overseas, if the process took place overseas, the country in which the surrogacy arrangement took place, and what was attractive about that country. And if you think you faced barriers because of certain personal characteristics, for example, if you're in a same-sex relationship or from a culturally or linguistically diverse background. You might also want to have a look at the issues paper And again, go to www.alrc.gov.au. You'll see the surrogacy review, and from there, click on the links to look at the issue paper. The second question is, what reform principles should guide this inquiry? Now, one of the things that stands out to me are numbers. Now, it's often said, well, we should ban Australians from undertaking surrogacy overseas. And the law in this area is remarkably complex. My first surrogacy journey I advised on was way back in 1988. And since then, I've been privileged to advise in over 2,000 surrogacy journeys for clients throughout Australia and 39 other countries. One of the things that I've done for a long time is to look at the statistics about how many children are born through surrogacy, and they're stark. It doesn't matter that Queensland, New South Wales, and the ACT have clear bans on undertaking commercial surrogacy arrangements overseas by people who are ordinarily resident there, or in the case of New South Wales as well, those who consider New South Wales their permanent home. It doesn't matter that in South Australia, the Northern Territory and Western Australia, you could also be committing an offence in engaging commercial surrogacy overseas. And it doesn't matter if the form of surrogacy overseas is adoption, because you could be caught by laws in every state and territory. And I say it doesn't matter because the statistics demonstrate that the laws that ban Australians from undertaking surrogacy overseas don't work. There's only been one prosecution ever for anyone undertaking surrogacy overseas, and of all places, that was in Victoria in 2008. There's been none since. So all these wave of laws that we're looking at generally came in the 2010s, and not one prosecution under them. And what do we see from the other numbers? Well, the number of children born through surrogacy in Australia between 2009 and 2022, which is the most recent available data, is 648. By comparison, the number of children born between 2009 and 2024 overseas is greater than 3,155. Now, that 648 figure slightly understates the amount of surrogacy that has happened in Australia. It is the amount of number of births of gestational surrogacy arrangements, which have been facilitated by Australian IVF clinics. So there will be a small number, say about another 5%, of traditional surrogacy arrangements. And if you don't know the difference, gestational surrogacy is where the surrogate is not the genetic mother, and traditional surrogacy is where the surrogate is the genetic mother. On the other hand, that 3,155 is also slightly understated. Way back in the early days, when there was a small amount of surrogacy happening, the Australian government said that the number of children, if they are less than 10, it would say less than 10 for privacy reasons. So that number of 3,155 is going to be slightly higher than that. But in addition, we have, and they concern children who have obtained who have applied for Australian citizenship by descent, who are born overseas through surrogacy. One of the unique features about Australia is that we keep data on the number of children born overseas through surrogacy and also where they were born. And it's enlightening. It's often thought that Australian intended parents who do surrogacy overseas only go to known destination countries, and currently countries like the United States, Canada, Mexico, or Colombia. The reality is that we are a migrant diverse country, and many Australian intended parents go back to the country from which they came because they know it. They know that surrogacy is available there, and then undertake surrogacy there. Now, this is only a small portion, but it's a significant portion. So in addition to those surrogacy destination countries, we see Australians going to places like Ghana, Nigeria, Iran, Bangladesh, Sri Lanka, for example. And that figure of 3155 is also understated because we have visa holders, so for example, permanent residents living in Australia, undertaking surrogacy overseas. Those children are known to the Department of Home Affairs, but they're not collated in that statistic because that statistic is only about applications for Australian citizenship by descent. But I digress. I'll go on to question 3. Question 3 is about human rights. What do you think are the key human rights issues raised by domestic and/or international surrogacy arrangements? How should these be addressed? Question 4, what information about the circumstances of their birth do you think children born through surrogacy should have access to? How should this be provided or facilitated? And then there are insights about the key issues and potential reform options. And the first one concerns barriers to domestic surrogacy. Question 5, what do you think are the main barriers that prevent people from entering surrogacy arrangements in Australia? How could these be overcome? You might want to consider the experiences of any groups who may face greater barriers to accessing domestic surrogacy than others, such as LGBTQIA+ people, people who are financially disadvantaged, or people from culturally and linguistically diverse backgrounds. Question 6 concerns eligibility requirements for surrogacy. Should there be eligibility requirements for surrogacy? If so, what should those requirements be? Question 7, are there any eligibility requirements which should be introduced, changed, or removed? And question 8 concerns surrogacy agreements, validity and enforceability. Are there any requirements for a valid surrogacy agreement you think should be introduced, removed, or changed? And question 9, should surrogacy agreements be enforceable? You might want to consider A, if all parts of the agreement should be enforceable, B, who should be able to enforce the agreement, and C, how agreements could be enforced. The next question concerns process requirements for surrogacy. So question 10, what process requirements should be in place for surrogacy arrangements? You might want to consider A, if counselling should also be available after the child's birth, B, what should happen if legal advice and counselling are not provided before entering a surrogacy agreement, and C, if parentage applications should require proof of legal advice and/or counselling. The next series of topics concerns professional services, including legal services like mine and counselling services. Question 11, what are the gaps in professional services for surrogacy in Australia? You might want to consider A, if surrogacy arrangements should operate in Australia, and B, the availability, accessibility and subject matter to be covered in legal advice and counselling sessions. Question 12, how should professional services operate in Australia? You might want to consider A, what their role should be, B, if they should be for profit or not for profit, or how should they be funded, C, if different types of services should operate together or separately, for example, whether counselling services should be independent or integrated within agencies or fertility clinics, and D, how they could best meet the diverse needs and experiences of people involved in a surrogacy arrangement. The next series of questions, I'm sorry there are so many questions, but this is a really comprehensive review, concerns limits on advertising. Question 13, how should surrogacy advertising be regulated? You might want to consider A, if advertising should be allowed, B, who should be allowed to advertise, C, what advertising content should be allowed, and D, where advertising should be allowed, for example, via newspapers, social media, or by establishing a surrogacy register. Next concerns access to Medicare and parental leave. Question 14, what entitlements, if any, should be available to surrogates and intended parents? You might want to consider A, Medicare rebates for the fertility treatments. B, access by surrogates to paid or unpaid parental leave, including through enterprise agreement terms. And C, if it is desirable to make surrogacy arrangements generally more affordable, and how this could be achieved. The next concerns payment, or as they say, reimbursing and compensating surrogates. Question 15, how could the process for reimbursing surrogates for reasonable expenses be improved? You might want to consider A, what expenses should be reimbursable. B, how payments should be calculated. C, if there should be limits on any amounts. D, the process for reimbursement. For example, whether money should be kept in trust, whether there should be a requirement to produce receipts, etc. And E, any jurisdictions, either within Australia or overseas, that have processes for reimbursement worth learning from. And you can see from a lot of these questions that they're highly technical questions. Many of these questions may not apply to you. I only cover those things that resonate with you, where you think it worked or didn't work, and how it might be improved. Question 16, do you support A, compensated surrogacy, and or B, commercial surrogacy? You might want to consider whether you agree with how we have described compensated and commercial surrogacy. Question 17, if Australia was to allow for compensated or commercial surrogacy, how could this be implemented? You might want to consider A, how compensation should be calculated, B, if there should be a limit on the amount of compensation, C, who should set the amount of compensation, D, the process for compensation, for example, whether it should be paid in monthly installments, whether the money should be kept in trust, etc. And E, any jurisdiction, either within Australia or overseas, that have processes for compensation worth learning from. Next, legal parentage of children born through surrogacy. And for me, this is a really sore point because too often it has been extraordinarily difficult to establish parentage. Local processes are very slow, and we have limping parentage. We have intended parents who successfully undertake surrogacy overseas and then end up with limping parentage back here. And critically, from my point of view, the person at the centre of this, the child, their parentage isn't secured. It doesn't reflect, often doesn't reflect reality. So, question 18, what are the main problems with the requirements and processes for obtaining legal parentage for a child born through domestic and or international surrogacy? Question 19, how could the process for intended parents to become the legal parents of children born through surrogacy be improved? You might want to consider A, timing. For example, if the process happens before or after the birth of the child. B, who makes the decision? For example, if it is an administrative or judicial decision. C, if recognition should be automatic. D, if the process should be different depending on the circumstances. For example, based on whether the surrogate has a genetic link to the child, the type of payment they received, and whether the surrogacy arrangement was in Australia or overseas. E, whether intended mothers are or should be treated differently to intended fathers in legal parentage determinations. F, whether the granting of legal parentage should depend on compliance with process requirements. G, the importance of prioritising the best interests of the child. And H, whether we can learn from the processes of any other countries. And then we're getting towards the end. I'm sorry, this is really complex, but as we know, surrogacy is the most complex form of reproduction, and international surrogacy is the most complex form of surrogacy. Citizenship, passports and visas. Question 20. What, if any, are the main problems with obtaining the following documents for a child born through international surrogacy? A, Australian citizenship, B, an Australian passport, or C, an Australian visa. Question 21. How could the process for obtaining these documents be improved? Oversight and harmonisation in consistent laws. I've certainly banged on about this for a long time, and slowly we've had some change, but not enough. Question 22, what is the best way to approach differences in surrogacy regulation between or within jurisdictions? You might want to consider A, the ways in which surrogacy regulation is inconsistent between jurisdictions. B, if these inconsistencies are problematic. C, any impacts of the differences between federal legal regimes, for example, citizenship law and family law. D, if a judicial process for transferring legal parentage is retained, whether applications for parentage should be determined in state courts, the Federal Circuit and Family Court of Australia, or both. E, how important it is that the approaches are harmonised or made more consistent. And F, how any harmonisation could be achieved, for example, by regulating surrogacy at a federal level or through uniform or substantively consistent state legislation. And then we deal with oversight and harmonisation. Oversight. Question 23. Is it appropriate for surrogacy arrangements to be subject to oversight? If so, what is the best approach? You might want to consider A, the need for a regulator or oversight body and what it could look like, for example, an administrative body or a tribunal. B, if oversight should be national or state territory based, and C, which groups need oversight, for example, health professionals. Next is the role of the criminal law. Question 24, should the law have a role in discouraging or prohibiting certain forms of surrogacy? You may wish to consider A, if engaging in or facilitating certain forms of surrogacy, whether in Australia or overseas, should be sanctioned or criminalised. B, the effect of using the criminal law to regulate certain forms of surrogacy, and C, whether there are regulatory approaches preferable to the criminal law. And we're almost at the end. Lack of awareness and education. And boy, have I heard this for more years than I have fingers and toes. Question 25. Do you think there is a need to improve awareness and understanding of surrogacy laws, policies, and practices? You might think about how people currently find out about surrogacy or the particular groups or professions who could benefit from improved education and information. Next one is issues we consider to be out of scope. Question 26. Do you have any views about the issues we consider to be in or out of scope? So you've got to look at the issues paper. You can't squib that one. And finally, other insights in question 27. Are there any important issues with regulating surrogacy that we have not identified in the issues paper? Do you have any other ideas for reforming how surrogacy is regulated? So as I said at the beginning of this video, please, oh please, put in a submission. Go to www.alrc.gov.au and follow the links about the surrogacy review about how to do it. The last day to put in submissions is Friday, 11 July 2025. By all means, share the submission with me if you feel comfortable. Stephen, S-T-E-P-H-E-N, at page, P-A-G-E, Provan, P-R-O-V-A-N.com.au. One issue that is a standout is that if you were born through surrogacy or a party to a surrogacy arrangement, the ALRC is looking very carefully at preserving your anonymity. That might be for the obvious one. There might be family law implications, privacy implications for the child or the parties. Indeed, depending on where you might live, there might be a breach of criminal law if not everyone has agreed to release the information. These protections are intended so that there can be a frank discussion. And I should have said that there are some people, of course, who have gone overseas and undertaken commercial surrogacy and are worried that they might have committed a criminal offence and be at risk of criminal prosecution if they are identified. So by all means, speak to the ALRC, satisfy yourselves about the privacy provisions. They're doing all they can to ensure that people speak to them and put submissions so that they can get a more and better informed response and therefore come up with better recommendations. Thank you for watching and listening. I'm Stephen Page from Page Provan. And as I said at the beginning of this video, I'm very proud to be a dad through surrogacy.